The coins alert is the source of all of the information that is described in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Please take a look at this recent event that has occurred on the SEC front. After the lengthy legal battle between Ripple and the SEC, which had been going on for a month, the court has been presented with a fresh request. This comes after the conclusion of the conflict. One of the decisions that was made was that trading of XRP on exchanges was permitted. Ripple was charged a fine of $125 million as well. Ripple and the cryptocurrency market were delighted with the $125 million sentence because the U.S. Securities and Exchange Commission had wanted a penalty of $2 billion. In spite of this, the parties were able to come to an arrangement of postponing the payment of the $120 million fine. In a petition that was submitted to the Southern District Court of New York yesterday, Ripple requested that the payment of a fine that was greater than $125 million be delayed. Within the petition, the legal team that is representing Ripple proposed that a penalty sum of $100,000, which is equivalent to about $130 million, be deposited into a bank account either prior to the conclusion of the appeal period or within 30 days of the conclusion of the appeal. Although the request for a postponement was granted by the Securities and Exchange Commission, Ripple's conduct was interpreted as an appeal of the decision that was issued by the SEC. Ripple's decision to postpone payment of the penalty rather than pay the penalty itself, as well as the fact that the SEC allowed the postponement, was interpreted as a sign that the SEC was still considering the option of appealing the decision and that the legal process was not yet finished. This was the case because the SEC allowed the postponement. In the event that the court offers its formal authorization to postpone the sentence of Ripple, it is likely that the sentencing could be delayed. Due to the fact that Judge Analista Torres has not given his consent, the postponement will not be considered genuine. Upon being questioned about the ruling handed down by the court, Ripple's CEO Brad Garlinghouse reacted to it as a success for the company. Ripple has requested that the payment of a fine in the amount of $125 million be allowed to be delayed. The SEC, on the other hand, was in agreement with the circumstances that were proposed. As a result of this, there has been some talk on the likelihood of being filed an appeal. The legal events have not had a substantial impact on the price of XRP, and it continues to trade at roughly $0.55. This implies that the price has not been severely influenced. The most recent material, which was obtained at the beginning of August, represents a critical milestone in the continuing legal battle that is taking place between Ripple and the United States Securities and Exchange Commission sitting. When the corporation was found to have violated many securities regulations, Judge Torres issued an order that mandated the corporation to pay a fine of $125 million. This amount was a small portion of the initial demand that was made by the administrative body, which was for $2 billion. Several of Ripple's top executives, such as Chief Legal Officer Stuart Alderode and Chief Brian Garlinghouse, appear to have expressed contentment with the decision that was handed down by the magistrates. As part of their commitment to comply with the regulations, they promised to pay the amount in cash from the balance sheet of the company. Despite the fact that a number of users of X have predicted that the company may reach a settlement with the agency as soon as this week, neither the company nor the agency has made any statements regarding the matter under discussion. A fresh petition has just been presented by the legal team that is representing Ripple. In this move, they are requesting that the monetary component of the judgment that was entered by the court 1 month ago be put on hold. This information was released by the company, which stated that the Securities and Exchange Commission had given its approval to the proposed terms and the postponement of the payment, which was originally planned to take place on September 6th. As a kind of security, the legal team representing Ripple suggested that a transfer of roughly $138 million may be made to the bank account of the legal team, which would equate to approximately $111 million of the total amount. It has been indicated that the funds will continue to be held in the account until 30 days after the time for submitting an appeal has passed. For your convenience, please keep in mind that both parties have the opportunity to contest the ruling until the beginning of October. Kellogg Hansen, one of Ripple's attorneys, will make sure that the cash stays in the account until it is either released by a court order or through an agreement between both sides. This will be done by the time the movie is over. In the event that the Court of Appeals decides to overturn or amend the verdict, the parties will make an honest effort to come to an agreement regarding the right way to handle the fund, and they will present any disagreements that they are unable to address by themselves to the court. According to the letter, the judges will finally decide whether or not to change the ruling or determine whether or not to vacate it. One or more personnel within the company were under the belief that this action would serve as a precursor to an appeal that could be submitted by the Securities and Exchange Commission (SEC). Fred Rispoli, an attorney from the United States, is one of the individuals that is in agreement with this concept. According to him, the fact that all of this work was put into forming a trust for the cash increases the likelihood of an appeal being filed, I believe. When all is said and done, on the other hand, this is the most foreseeable action that the Securities and Exchange Commission (SEC) may take in order to buy time before the deadline to appeal on October 7th. Potential examples of cross-appeal: former attorneys for the Securities and Exchange Commission, such as James Farrell and Mark Fagel, have expressed optimism that the SEC may be able to submit an appeal before the deadline of 60 days, which would expire at the beginning of October. This would be a cross-appeal. Ripple, on the other hand, would be compelled to file a cross-appeal with the Second Circuit Court in order to fight the verdict in a more comprehensive manner. In the event that Ripple makes the decision not to file a cross-appeal, it will effectively accept the $125 million penalty without any further dispute. This will limit the court's ability to address additional issues. After the release of the stay petitions, Ripple's chief legal officer, Stuart Alderode, has maintained his optimism that an appeal will not significantly alter the outcome of the case. This optimism pertains to the fact that the stay requests were announced. He feels that the Securities and Exchange Commission has a 10% probability of overturning the verdict if they have the opportunity to appeal the decision. Due to the lack of clarity around the Ripple CC lawsuit, the price of XRP has been significantly impacted. This is because of the ambiguity surrounding the issue. Every single one of the coin's recent gains has been lost. XRP is currently trading at a price of $0.55, and the number of transactions has declined by 15 over the course of the past 24 hours. The open interest in XRP futures has also decreased by 0.67, which is an indication of the declining interest from derivatives traders over the next several months. This decline in open interest is a reflection of the previous trend. The SEC and Ripple will need to make a decision regarding their legal possibilities. In the event that the appeal is permitted to proceed, the Bitcoin business may be more anxious than usual. It is important for holders of XRP to keep a watch out for any resolutions that could potentially have an effect on the cryptocurrency market, regarding the question of whether or not the top regulator will appeal the partial success that took place on August 7th. There is a lack of clarity within the XRP community. They are allowed to contest the verdict until the 6th of October. Despite the fact that Ripple and the XRP community have been able to realize some level of progress in their dispute with the SEC, it is probable that the drama will not be resolved anytime soon. As the time for the Securities and Exchange Commission to file an appeal creeps closer, it is probable that tensions could once again increase. As time goes on, will the situation become more serious? Continue reading to learn more about this topic. In a recent post on X, attorney Jeremy Hogan made a hypothesis that the Securities and Exchange Commission (SEC) may not have yet decided whether or not to appeal the Ripple litigation. Hogan's claim was made in the context of a hypothetical situation. It was brought to Hogan's attention that the procedure for submitting a notice of appeal is a straightforward and efficient one that can be finished in a mere 15 minutes. Following the filing of the notice, the Securities and Exchange Commission would have a final deadline of 70 days to submit the actual brief. Hogan is of the opinion that the Securities and Exchange Commission would not delay filing if they had already decided to appeal the verdict. This is especially true given that the ruling that is currently in effect does not favor their point of view. Both Ripple and the CC have submitted a request to have the monetary judgment put on hold.